Hi everyone, we are excited to bring you another live Capitol Hill update. I'm Tabitha Walter, the Political Director of Eagle Forum, and this is Kirsten Hasler, Executive Director of Eagle Forum.
Thanks, Tabitha. We want to bring you a quick update on some rulings out of the Supreme Court this week. In a victorious 7-2 decision in Little Sisters of the Poor, Saints Peter and Paul Home versus Pennsylvania, the court ruled that the Little Sisters are exempt from the Affordable Care Act's contraceptive mandate. Now, you may remember that the Little Sisters are an order of Roman Catholic religious sisters who serve the elderly poor. In the past decade, they have been dragged through multiple courtrooms fighting for protections against being forced to fund healthcare plans required under the Obamacare contraceptive mandate.
Now, this mandate requires healthcare plans to provide women's preventative care, including birth control and abortion-inducing drugs. Initially, the Obama-era rule only included very narrow exemptions, and then in 2016, the Supreme Court upheld an exemption for Little Sisters. To add to this, in 2018, the Department of Health and Human Services issued further guidance and exemptions protecting the conscious rights of Americans. And following the announcement of this 2018 rule, a handful of states filed suit against the federal government. Pennsylvania and New Jersey successfully blocked the rule in their lower courts, and the Little Sisters headed back to the Supreme Court. So, we are hopeful that once and for all, the Little Sisters will be able to continue their noble work without government interference.
This decision was certainly a win for the First Amendment and religious liberty. Well, to add to this, the court ruled in another case, Guadalupe School versus Mauricio Bru, in a 7-2 decision also, that religious schools could not be forced to hire teachers that do not follow the school's faith and religious practices. The court deemed that the ministerial exemption in civil rights law, which allows for religious institutions to hire and fire ministers as they see fit, extends to teachers working at religious schools. So this decision ensures that these religious schools are not forced to compromise their beliefs in their hiring and firing practices, and ensures that their teachers are always a reflection of the teaching that they desire to bestow on their students. We are grateful to our justices for upholding the First Amendment in both of these rulings.
Absolutely. Now, the last ruling that we'd like to highlight is a case that consolidated 3 cases regarding President Trump's tax returns. To give a little background on this case, New York's Manhattan prosecutor Cy Vance subpoenaed 8 years' worth of President Trump's tax returns in order to investigate alleged hush money payments. House Democrats also tried to get their hands on his tax returns on a separate occasion to investigate foreign interference. The president's attorneys sued, arguing that since a sitting president cannot be indicted, he is not subject to the judicial process either. Now, just this morning, the Supreme Court ruled 7-2 to allow District Attorney Vance to proceed with his subpoena, but rejected the House's efforts. This doesn't mean that we will see what is in his tax returns, though, especially before the November election. They are subject to a secret grand jury who are supposed to operate with confidentiality. A leak, however, could really upset the president's re-election efforts this November.
Certainly a hard decision.
Mm-hmm.
If you'd like to stay up to date on issues, please visit eagleforum.org and sign up for our email. You can also sign up for our Eagle Forum report that is delivered straight to your mailbox once a month, and follow our social media pages for more timely information. If you have any questions, feel free to drop them below this box, and don't forget to share this with your friends. We hope to see you back here next Thursday at 2 p.m. Eastern. Talk to you later.
See ya.